Hi everyone, as you can see, it's just me today. I'm all alone. No Andrew today. Unfortunately, he couldn't be here, but he does send his regards to you all. So please be kind as you're watching this one, as I will have to cope all by my lonesome. Today is a really interesting week. As you can see, the main topic today is medical cannabis, which surprisingly has come up a lot and more frequently. More and more we're seeing employees having to use this to cope with certain conditions. And it's an interesting discussion about, well, what is the impairment and is it impacting on their work? Does it veer into the levels of intoxication? And how do you manage that as an employer? So we'll dive into that a little bit. The news items that you'll see us discuss today, a lot of new changes in the law in the various jurisdictions. I just want to start with some of the new changes that have come in New South Wales. So we've seen a huge increase in on-the-spot fines by 25%. So maximum fines of $4,500 for body corporates and $900 for individuals. They've also increased the number of different WHS offences where you can get on-the-spot fines. So employers in New South Wales really should pay attention for things like failing to notify, failing to have and not having a SWIMS for high-risk construction work, and things like failing to provide workers with adequate clean and safe facilities such as toilets. All of these types of offences will now mean that inspectors can issue you a fine on the spot instead of going through a prosecution. We've also seen the introduction, or the reintroduction, I should say, of the industrial court in New South Wales. This is intended to be run by specialised health and safety judges, and they're purely going to focus on industrial and WHS claims. So it's going to be really interesting to see how this operates. As we all know, it used to operate and then it got closed down. So hopefully it can achieve all that it has set out to do. Andrew will no doubt tell you his views on this, but I suspect he would say that it's more of a political tool than anything else, but let's wait and see. All right, on to the news items of this week. So the first one is Delegates Rights clause. I think you all would have heard about this. The union have really tried to turn the spotlight on this, but essentially the Fair Work Commission, through a divided full bench actually, have decided on the finalised Delegates Rights clause to be introduced into all modern awards, and that happened on the 1st of July. If you are under an enterprise agreement which doesn't have a Delegates Rights clause, then the clause under whatever modern award would apply to your employees would stand as if it was in your enterprise agreement. So the Fair Work Commission have taken into account all of the submissions by the various employer bodies and have agreed that the term will be reviewed after 12 months. Delegates are people who are elected in accordance with the rules of the union and are able to represent workers at whatever business they're assigned to. Under the new clause, they actually do have to provide written notice to the employer of their appointment, but the rights basically just enshrine what's already in the Fair Work Act. So the right to represent employees' industrial instruments, this is now limited to only those employees who wish to be represented. There's an entitlement to reasonable communication with employees, entitlement to reasonable access to workplace facilities and the workplace itself, and they also get 5 days of paid time during working hours for their initial training and 1 day per year after that. That last one is not applicable to small businesses. Look, we will say that the final Delegates Rights clause is probably a move from what the initial draft clause was. So it's much less onerous on employees, particularly around access to workplace and facilities. And the fact that it is limited to only employees who wish to be represented is a big change. But to be honest with you, I think there is a lot of focus and talk about this, and we've had clients reach out in fear because they said, oh, look, what about all these new things? Is this new obligations for us? And the reality is it is a restatement of the existing right of entry laws. I don't think is going to have such a huge impact as the unions are suggesting. So I don't really think it's something to be worried about. Just be aware that it is there now and enshrined within the industrial instruments. All right, on to out-of-time applications. So this case was actually a case that I ran last week, I think it was, and we succeeded in this case. It was an out-of-time application in relation to a general protections application. So the employee in this case worked for an aged care provider, was terminated during probation because of performance issues, and brought a claim alleging that he was terminated because he made complaints around safety, that he had a condition that he allegedly got from working at the aged care provider, things like that. But his application was well out of time. I think it was 24 days after the 21-day time limit. So we brought a jurisdictional objection and said that the Fair Work Commission had no right to hear this claim, and that went to hearing. So how out-of-time hearings work is the Fair Work Commission has the discretion to extend the time to accept an application if there are what's called extenuating circumstances. And it is the onus is on the applicant to actually prove that they have extenuating circumstances, and it's quite a high threshold. So it should be exceptional circumstances. Exceptional circumstances are those that are out of the ordinary course, unusual, special, or uncommon. And it comes down to 5 factors under Section 366, subsection 2 of the Fair Work Act in relation to general protections applications, but it's the same factors for unfair dismissal. What is the reason for the delay, the action, whether the employee took any action to dispute the dismissal, any prejudice to the employer. Really, that one is usually not the case. It's unlikely that there would be any prejudice unless there was a very significant delay. The merits of the application, whether it's going to be successful or not, and fairness as between the person and other persons in a like position. So is there any other similar circumstance where another employee was in the same position and was granted an extension of time? And in this case, it really came down to the reasons for the delay. The employee stated that they were quite sick and was unable to prepare the application in time. Also made claims that they had to seek legal advice and that they had accidentally lodged the wrong application first. So they lodged an unfair dismissal application first. And the Fair Work Commission found there was no evidence at all of them seeking legal advice. There was no evidence of that at all. Also, it's not sufficient excuse to say you weren't aware of what the correct application was, because ignorance is not an exceptional circumstance. And also that application was filed out of time, so it was clearly not the reason for the delay. So the main thing was really whether the applicant's medical condition was a exceptional circumstance. And I made submissions that a medical condition in itself doesn't mean that you are incapable automatically, right? You have to prove that there was something about the medical condition that was debilitating or made it so that you were completely incapable of preparing the application within the time frame. And although the applicant provided medical evidence, there was no clarity about what condition he had. He was making his own self-diagnosis and the doctors weren't confirming it. And there was nothing in the symptoms that suggested he was unable to do this. Further, he actually provided a lot of evidence that during the 21-day time limit, he was going to medical appointments, pathology appointments, and things like that. So he was clearly capable of doing things, and there was nothing that was preventing him from filing an application. In fact, in the hearing itself, he actually said filing a legal application was not my first priority. So as you can imagine, the Fair Work Commission agreed with us and the application was thrown out. So it's just a reminder that if you do get an application where an employee has filed out of time, it is worth disputing and you should seek to bring a jurisdictional objection and really analyse what reasons they've put in there, because it's way more worth it than trying to fight it the whole way. All right, on to the next one. So we are seeing that there are new incident notification requirements in Victoria. They applied from the 1st of July. So under the OHS regs and the Equipment Public Safety Register regs, you have to notify of any incident that immediately or imminently exposes a person to risk because a plant has collapsed, overturned, failed, malfunctioned, or damaged. And the new changes have expanded the list of plant that would apply. So previously it was quite narrow and was very, very niche plant, I would say. Now it will include a lot of the more commonly used plants such as tractors, quad bikes, forklifts, excavators, and mining and quarrying equipment. So be careful, and if there are any incidents involving these plants, please make sure that you notify within 48 hours. All right, on to the next one. Okay, so this is an anti-bullying case involving a stop bullying order. It was more of an interim procedural decision. So the applicants in this case were drone operators and trainers, and they were bringing an application against the Civil Aviation Safety Authority, who administers their licenses. And basically, the employees said that the officers took an unfairly long time to approve their licenses and a bunch of other things. But basically, the officers in this case said, look, we don't agree that there has been any bullying, but we will make undertakings to make sure we do not initiate any contact with these employees. We will not attend that employer's premises and will not be involved in any licensing matter involving this one specific employee who had brought this claim. And the employees weren't happy with that. They brought another application and on the same grounds and included two other officers. And the Fair Work Commission found that, look, while it has a really wide-ranging power to oversee different types of cases involving bullying, whether it's considered to be at work or not depends on the circumstances. And in this case, there was a right to appeal these kinds of decisions because they were administrative decisions under different legislation, and the Fair Work Commission had no jurisdiction to review the licensing decisions. I think they were being very kind in this case because they've allowed the case to continue but have put the employees on notice that they have to particularize the bullying. But I think it's a really good case to show you that not everything will be considered bullying. Like Andrew and I have talked about this week after week, there is a very high threshold to meet what constitutes bullying. And I think we've seen this misunderstanding or even this purposeful action by employees to just lump everything in as bullying. And the Fair Work Commission is drawing a line in the sand and saying, no, we are not going to look at every case, particularly ones which should really be in another jurisdiction. All right. On to the next case. I'm going to move through because I think we've got a few cases. All right, so this is a labour hire case where a labour hire worker was injured in a quad bike rollover. And the host employer was the one who was charged with Section 46 of the New South Wales Work Health and Safety Act, mainly around their lack of consultation with the labour hire provider. They were fined $180,000 for the Section 19 breach and $15,000 for the Section 46 breach, so around $195,000. That's not what is so unique about this case. I think what was really good is Judge Russell in this case actually went through in the case about what are the duties between a host employer and a labour hire provider, because there is this mistaken understanding or misconception that it is possible to just delegate the duties in a contract. I constantly get this question all the time, and they'll always be like, look, our contract says that's the labour hire provider's responsibility, so then it's not our liability. And it doesn't work. They're not delegable duties. Each entity has their own separate obligations, and if you don't comply, you will all be liable. It's not like a common law claim where it is going to be apportioned. So in this case, the judge found that the responsibility of hosts is to verify with the labour hire provider that the workers have the necessary qualifications, licenses, skills, and training to carry out the work safely. And they have to consult with the labour hire provider on WH matters, including who's going to provide the required equipment and PPE. For labour hire providers, they have to get information on the specific work being undertaken by the workers. and what skills and knowledge will be required so that they can ensure that their workers are competent and able to do that. They also have to make sure that the host provider does site-specific and task-specific inductions, training and PPE so that it will be safe for them to undertake that work. And finally, they have to ensure that their own employees have all the necessary qualifications, licenses, and training so that they can undertake the work safely. So it's a good reminder on what are the different obligations and how you can comply with your duty to consult with the other provider. All right, I think we're now on to the last case, which is a significant fine. This business was fined over $720,000. So in September of 2019, a worker was seriously injured because part of the mine roof collapsed and injured them. And only 2 months later, another mine electrician was killed because of falling material from a coalface. So you can see that they're very similar offending, and basically not very much had been done in that 2 months to mitigate the risk, the very significant risk of something falling. So Scarborough Downs was charged with 2 breaches of Section 34 of the Queensland Coal Mining Safety and Health Act because they hadn't basically looked into ensuring that the risks were mitigated to an acceptable level, and specifically that they hadn't ensured workers were avoiding restricted zones with defective safety devices, and they hadn't been completing safety checks. So in the end, they were fined $720,000, $480,000 for the fatality, $240,000 for the injury, and no conviction was recorded. So while I think this is not a particularly unique case, what it reminds us of is if you have a serious incident, please make sure you are doing an investigation under legal professional privilege. An OHS consultant can do an inspection under privilege and can work out where the gaps are in your system and the controls needed to rectify the problem. It is so important to do this so that you can fix the system, protect the knowledge from the regulator, but also it will avoid another incident which could expose you to more aggravated charges, particularly if you had a similar incident and nothing was fixed. I think this would have been a very different situation if the company in this case had just put steps in place within those 2 months. If there was evidence that they were doing something to mitigate the risk and then something else happened out of their control, it would have been a very, very different story. All right, on to the main topic. Okay, medical cannabis and fitness for work. So we are definitely, like I said before, seeing more and more examples of employees needing to use medical cannabis to treat different medical conditions. Unfortunately, the reality is there is no current reliable evidence regarding the actual impact of medical cannabis on employees or people. We know that there is some kind of impact, but there is no accurate tests so that you could pinpoint with certainty what is the level of impairment. And then we get into the difficulty of the fact that if they need to use this to treat a medical condition, then it probably would constitute as a disability and therefore a protected attribute under discrimination law. So refusing to allow them to use the medical cannabis could be discrimination. But as we all know, it is possible to discriminate against someone if the reason you're doing so is for health and safety. And in this case, if we're aware that employees are ingesting medical cannabis and it is impairing their ability to work and their fitness to work, particularly if they are undertaking work where there's high risk, such as operating heavy plant and machinery, you are certainly able to take steps to verify their impairment. And if it's clear that they cannot perform the inherent requirements of the job, you can take disciplinary action, including termination on that basis, because it's not discrimination, because they cannot perform the inherent requirements of the job. So I want to look at the case of Bunce and PM Fresh. It is not specifically on medical cannabis, but it is involving an employee who has ingested cannabis. So the employee in question was involved in a forklift incident. So it was basically a safety incident. No one was hurt, but it was clear they were impaired. They weren't driving it safely, and they reversed into different pallets that they had previously placed on the floor. And when the employer did an investigation and questioned the employee admitted that they had ingested cannabis or smoked marijuana the night before, and that they were an active user of cannabis for 35 years but had never smoked before attending to work. So the employer said, look, I don't think we need to send you to get tested because I'm pretty certain you would get a positive result. And the employee agreed that it would definitely come back positive. And basically, the employer finalised the investigation and terminated the employee. At the hearing with the Fair Work Commission, the employee said, look, there was no evidence of my level of impairment. The employer never did that. And while the Fair Work Commission found that there were procedural deficiencies in this case, so the employer had done the investigation but had never informed the employee of the findings or really given them a chance to respond, had just terminated them. In this case, there was enough evidence of the level of impairment. So the employee admitted that they would have tested positive to cannabis. They were showing clear signs that they were not able to, they were struggling with their memory, and it was clear that they weren't in a fit state for work. So the commissioner in this instance said that although there were no accurate tests to be able to define with certainty the level of impairment, that was enough to constitute a valid reason. And the fact that the employee knew that they were impaired and were still driving heavy machinery definitely constituted serious misconduct. So the unfair dismissal was dismissed. So it's a really interesting topic because you're stuck with this hard place where the current tools that we have to assess medical cannabis just really isn't up to the standard that we need. But what we would recommend that you do is monitor the trends regarding it and check if there is any updates in this and to use that. But please review your alcohol and drug policy and procedure. It should be very clear about when you can use it, if people are displaying signs of impairment, what you should do. So you should be able to send them to get a medical clearance. And if you are of the view that they need to be dismissed because one, they are not fit for work and they can't do it and it's a very high risk, then definitely you can take those steps to make sure you are complying with procedural fairness. You have established that there is no fitness for work and you've got the medical evidence to support that, and go down the inherent requirements route. Okay, on to the case study. Okay, so Gus was a forklift driver at Bear Warehouse. Terrible name, Andrew. An underwear wholesaler. The warehouse was meant to be automated by 2023, but they ran out of cash and the old part still had employees picking and packing where forklifts moved in the same area as pickers. Gus suffered from migraines and anxiety. Dr. Hoodoo Guru, a locum at the local medical centre, prescribed him medicinal cannabis. Gus loved it as it worked. Bear Warehouse had a zero drugs tolerance for non-prescribed drugs that impaired judgment for plant operators. It also required plant operators to declare prescribed medications that could impair judgment. The policy gave no threshold blood levels or examples of prescribed medications. Although it allowed the employer to direct testing, there had been no consultation on the policy and it was not referred to within employee contracts of employment. His supervisor, Kel, directed Gus to stop driving and get off the forklift on Monday morning. Kel had seen him drive by and nearly hit a picker and noticed he seemed out of it and disoriented. When Gus got off the forklift, he slipped, wobbled, and nearly fell. It was like he was out of it. Kel directed him to undertake a drug test. Gus told him to shove it and said he was going home and he would not be bullied by Kel. Kel directed him again to stay at work and be tested, but Gus kept walking. Kel heard from others that Gus was on medicinal cannabis, so he sent him a text saying he was not to present to work until he had a doctor's clearance, stating he was free from cannabis and he would be getting a show cause letter in any event, asking him why his employment should not be terminated. Gus replied saying, "Stick it up, your A. I will be taking 2 more cannabis tablets tonight because of you." So, if Gus's anxiety went through the roof as a result of Kel's conduct towards him, would his workers' compensation claim be accepted? Undoubtedly. So anxiety is a diagnosed condition, assuming he got the proof from the doctor. And in this case, Kel's conduct would not be considered reasonable management action. The actions he was taking were not one supported by the policy, and it would never, ever be considered reasonable to send people information about disciplinary procedures through text. The way that he handled it also was very aggressive. So reasonable management action, it has to be a proportionate response, and in this case, it just definitely wasn't. Was the policy effective? No. As it was made clear in the case scenario, it failed to properly define testing levels, methods of testing, description of when testing would occur, and no definition of impairment at all. Also, the biggest thing is there was no consultation on the policy, so it would not be valid or enforceable. So any testing done on the policy would not be reasonable or a lawful reasonable direction. Was it reasonable for Cal to give Gus the direction about medicinal cannabis? So the fact that Gus was showing signs that he was not fit for work, all those symptoms, he was wobbling, he wasn't operating things well. As an employer, you are more than within your rights to immediately tell them to stop work. Although he couldn't order him to go test because the policy was defective, he was well within his rights to tell Gus to go get a medical clearance because he clearly was not fit for work. Did Cal have to test Gus to terminate his employment? That's the strange thing about this process, which I guess Andrew wrote. He didn't have to do any of that. So the much simpler way of terminating in this case was the fact that Gus was clearly not fit for work. He was operating the forklifts unsafely. He had a near miss and almost seriously injured someone else. So his actions would have fallen under serious misconduct under Regulation 1.07 of the Fair Work Regulations anyway, because it was an imminent safety risk. So they could have just terminated him for serious misconduct without having to go down this testing and impairment and intoxication route. Was Bear Ware at risk of a safety prosecution if it knew others may be using medicinal cannabis but did not update, consult, and fix its policies and processes? Yes, because if it's aware that there's a risk breach in its policies and it isn't able to order testing, then there's no way for it to ascertain the level of impairment of these workers. And if anyone is impaired and then ends up hurting someone else, then they were aware of a risk, they can fix it. There's real risk of reckless endangerment in those cases. When would Gus be fit to return to work if he stopped using cannabis? So this is probably the trickiest question, because the answer is it's pretty unclear. At the moment, there is no accurate testing as to the level of impairment. You'd have to wait for a doctor to give that clearance, and the current studies say that it stays in your system for quite a long time. We'd say probably 3 or 4 days at least he would need. But at that case, then you start veering into, well, if you stop them from using it and they need it for their medical condition, is that then discriminatory? But also, if it's impairing their work, then they can't perform the inherent requirements of the job. So really just wanted to flag this and raise it to your attention, because it is a more common issue we're seeing, but it's definitely a watch this space topic as we see medical improvements improve the testing so that it can be more accurate. So thank you for joining me this week. Please give me a thumbs up, but please let Andrew know I didn't do well so that he has to come back. But yeah, we'll see you next week. Thank you. Bye.